reserve 7 minutes for rebuttal. We're here because the agency insists its referee can sua sponte change the outcome of a reemployment benefits case after a decision is final. They contend that the referee only corrected a clerical mistake, but no changes are allowed after a decision is final, clerical or otherwise. Moreover, the corrected decision wasn't corrective or clerical. The changes the referee made changed the outcome of the case for WHS Trucking. And such action is contrary to the statute that makes the decision final and the agency's own rules that prohibit substantive changes at any time after a decision is issued. The department's referee had no jurisdiction to change the order on its own initiative after it became final. Florida agencies don't have any authority or jurisdiction beyond that granted by statute. The statute didn't allow the referee to sua sponte change the decision after it became final.
So how do they fix it if they make a mistake of law? You know, obviously this is inconsistent. If they make a mistake of law and render an inconsistent opinion, how's it fixed? Is there any way to fix it?
First, we don't think that it was inconsistent. There's a statement in the initial decision that very clearly states that WHS Trucking would not be charged for the benefits that Mr. Henry would receive.
Yeah, but as I understand the law, if the employee is entitled to benefits, the former employer is on the hook for it. And in the law, there's not any discretion to delink those things.
Well, there are a number of cases in which the commission, the outcome coming out of the commission was exactly that, where the claimant was permitted to get benefits, but the employer was not charged. But as far as being able to fix it, there's a very simple remedy. Before the decision's final, the department can file a motion, or it can take appeal, or the commission can actually initiate its own appeal. There are a number of very simple and easy ways to fix it, but here, none of that happened. Instead, the department sat on its hands and did nothing until after a notice to charge benefits was issued, and then issued a corrective decision to comport with the action that the department took contrary to the initial decision. So there are simple methods to do it, but even when you have a situation that you have a legal error in the order, the commission's prior decisions show that that winds up yielding to this jurisdictional issue that when the decision is final, anything that's issued after that has to be quashed. It's a nullity, it's void. And to decide anything else would really give the agency unlimited ability to correct a decision months or even years later. Some of these cases deal with agency attempts to change final decisions as much as a year later. There would never be any finality. And in the circumstances where that jurisdictional principle winds up yielding to equitable principles, they're not circumstances like what we have here at all. First, whether clerical or not, the agency is prohibited by statute and rule from changing a decision once it's final. To the extent that there might be inherent authority to be able to correct decisions in some circumstances, that inherent authority can't be used to override a rule or a statute. In cases like the Florida Supreme Court's case in Taylor, their amendments were allowed where there was a motion filed within the appeals period. And it allowed the agency to be able to correct beyond the jurisdictional period where due process required it. So,
well, isn't that their argument here? That the initial order was ambiguous and therefore may have lulled your client into failing to pursue the administrative appeal. So that, in fairness, they should clarify the order and give you that opportunity.
There is no case in which a party seeking further review was forced into further review by a corrective decision. This is not a circumstance where a party asked to obtain further review and was foreclosed in timely doing it because the agency lulled it into inaction, and then asked for the agency to vacate its order and enter a new one. Here, what the agency is proposing to do is force further review by entering a decision that comes to the opposite conclusion as the initial decision. there are no cases that support forcing a party into further review. In fact, that's exactly the concept that in Taylor, the Florida Supreme Court was warning against, where the time when you can correct a decision are in circumstances where it really doesn't interfere with administrative finality. The sentence that WHS would not be charged is very clear, and the commission has repeatedly, in this exact same circumstance, rejected the argument that a corrective decision could come back and fix the discrepancy between an employee receiving benefits and the employer being charged. In each of those cases, the commission wound up entering an order that quashed the corrective decision and reinstated the decision that allowed the claimant to have benefits, but did not charge the employer, and that's exactly the result that should occur here.
I know you're talking about the Sherman case. You
Yes.
say there are other cases like that?
There are, including the Tremazzo case, and there the corrective decision was quashed also because it was changing the non-charging statement of the employer to charging the employer, and the department was trying to do it on the basis of Rule 73B-20.0261, which prohibits substantive changes. It does not allow for clerical changes after the decision is final either. And so in those circumstances, the commission wound up quashing the corrective decision, and the fact that there might have been a mistake in the initial decision, which again, we don't agree that there was a mistake, but where there is a mistake, it cannot be corrected after the administrative orders become final, and that is because there is a statute and a rule that speak precisely to that.
But isn't Judge Roberts right that the statute says if benefits are awarded to the claimant, the employer should be charged?
If that was an argument that the department felt it could make, it was an argument that it should have raised before the decision was final. And because there have been cases in which we have employees that are getting benefits and the employer being no charged, I'm not sure that I agree that it's required in every case, or that there needs to be a corrective decision to fix it when the referee determines that an employee is going to get benefits and the employer is not going to be charged. And part of the reason that I say that too is because the statute allows for a referee to do three things when it's considering an agency's determination. It can affirm, or it can reverse, or it can modify. Now, if the referee never had any discretion to decide that an employee was going to get benefits and the employer would be non-charged, then you would only have two things. You would have affirm or you would have reverse, because the charging of the employer would naturally flow from whether or not there was misconduct. It seems to me like there is another category where the referee can modify the decision. The only thing that would be modified in any of these cases would be the decision to charge or non-charge the employer. I'm into my rebuttal time.
What about the length of a period of ineligibility for benefits? That might be modified.
Well, again, and that gets us into the agency's own rules regarding definitions of serious misconduct even. I mean, none of what the agency is saying here, including on the misconduct side of things, squares with its own rules defining what serious misconduct is, which comes up in the context of how many weeks you would wind up being ineligible for benefits. Here, part of the problem is that really the referee in the first instance should have found that this was misconduct, based on the fact that on the spectrum from Poole and Leister and Williams, those cases are cases in which there was no fault. They were car accidents that were mistakes and maybe a little bit of bad luck and incompetence. There weren't personal injuries coming out of them. Here, as the commission's order showed, this was not a slam dunk call on the misconduct side of things. When you look at the cases like Georges and the Amoco oil case involving the oil tanker, those cases are cases in which there was fault. You had a vehicle that was inherently dangerous, like here we have a logging truck, and the commission took great pain to try to weigh those things to determine whether this should have been misconduct or not. I'm not sure that the referee didn't have the ability to say this is a case in which it's a gray area on whether or not this should be misconduct, but at the end of the day, I'm going to allow the claimant benefits but I'm not going to charge the employer for those benefits. We do not agree that there was a mistake made that required correction, nor do we agree that the decisional paragraph in the initial decision required for the department to charge the employer in the light of the fact that there is a sentence that says WHS will not be charged. I'm into my rebuttal time unless you have further questions.
Good morning, Your Honors. Frank Brown, Chairman of the Commission. I'm arguing this case today because it touches some core policy concerns that affect the Department and the state of Florida in terms of how the operations of the Department of Economic Opportunity and the Office of Appeals work. I know that the court will have plenty of questions, but I ask your indulgence for a brief opening remarks that I think will help reframe the issue in this case to where it needs to be. The appellant's argument in this case is based on a fundamental assumption that we suggest is erroneous, and that is that the employer was, as a matter of law, non-charged in the original decision of the referee. Their entire argument's based on the fact that we won and then we lost. Our argument is...
But the order says that the employer won't be charged.
There's a paragraph in the conclusions of law that says the claimant will not be disqualified, but the employer will not be charged. That is, however, inconsistent with the decisional paragraph. I know that was a major focus of the initial and reply brief to the suggestion that basically we had something that we had concocted. So I wanted to make sure the court was aware of where that concept of the decisional paragraph comes from. It comes from a national model that's at least 40 years old and probably older than that. We provided last week in our supplemental authority the U.S. Department of Labor's Employment and Training Administration handbook. It's a federal standard on how decisions are to be conducted, written, and cases decided. And that paragraph 30 basically states that the order will contain, the decision of the referee will contain, a decisional paragraph that states the outcome of the case. Our statute and our rules are modeled on that. It may be a simplistic approach, Your Honor, but the long-standing interpretation of the Department and the Commission is that the decisional paragraph, that part that says decision, affirmed, etc., is dispositive. It's like the judgment entered in a civil case after a verdict or an order. What happens if your judgment is different from your verdict? You take the judgment to the clerk's office. What is the clerk going to issue a writ of execution on? The verdict? No. That judgment, that decisional paragraph is operationally important because of the way the Commission and the Department operates. Let me go through a little bit about what the Department has to deal with. In 2014, last year, the Department decided.
All right, so under your view, there didn't need to be a change.
There did need to be a change, but it did not change the outcome, and here's the reasons. Two of them. First, the federal standards require that our orders be, quote, correct. The original decision charged the employer that it was not, quote, correct. In other words, our orders are expected by the federal government to be sound, logically consistent. I think everyone would agree that by putting a phrase in the conclusions of law that is inconsistent with the decisional paragraph, you don't have a logically consistent order. That was clear. This was not a good order. Everyone acknowledges that. We would not debate that this was good practice at all. Secondly, as your question alluded to, consider what happens if the corrected decision is not issued. The employer has been charged in this case, and that's not disputed, Your Honor. I know that the appellant was questioning, why did we get charged? We won. Well, to the Department, they didn't win. And they got charged as a matter of course. However, by the time this happens, their time for appeal has run. Okay? For due process purposes, there has to be a point of entry for the appellant to come into the Commission and say, we should have won this case. There was misconduct in this case. And of course, they had the right to argue the jurisdictional issue as well, but as our decision clearly stated, no, the referee had jurisdiction under our rule because there was not a substantive change in the outcome. This case really turns on, Your Honor, this question. Who gets to decide what a substantive change is? If this court defers to the Commission's interpretation, our protocol, which is modeled on federal law, then the original decision was in fact a decision charging the employer, and the corrected decision needed to be made for the two reasons that I stated. And I would suggest to the court that you should give precedence to our interpretation for two reasons. First, I won't need to refer you to your own line of cases talking about deference to an agency's interpretation of its statute and its rules. But there's another principle that I don't know that we laid out in our brief in any detail, but I do want to point out to you. Those of you who have been on the court for a long time have certainly seen the rule of liberal construction in our statute that guides a lot of times in separation cases. But it has another portion that's particularly applicable to this case. This is 443.031. The legislature hereby declares its intention to provide for carrying out the purposes of this chapter in cooperation with the appropriate agencies of other states and the federal government. It goes on to cite Title III of the Social Security Act and the Federal Unemployment Tax Act. Last sentence of the paragraph. All doubts as to the proper construction of any provision of this chapter shall be resolved in favor of conformity with such requirements. And what that basically means is, if there is a question, if you default to the interpretation of the law or rules that is most harmonious with federal law. And that's what the court should do here. That's what the commission has done in establishing.
Were these federal laws cited below to anybody?
They were cited below. Well, they didn't come up below because we were responding in our order below to the arguments raised by the appellant. They were cited in this case only in the response to the, initially cited in this case in response to the motion for attorney's fees, in which we contended that the fees requested would be in violation of federal law. But we raised them in this case at this point by notice of supplemental authority, because it became clear after reviewing the rebuttal brief that the appellant was taking the contention that our concept of this decisional paragraph was something that had been made up. And I wanted to point out to the court, I think it's important for the court to understand that you're being asked to choose a path that is not the most consistent with federal law in this case, which is not a policy decision the court should undertake.
So is there any point that the findings of the referee actually become final?
Yes.
When's that?
Well, let me explain our interpretation of the three prior cases and why we did not apply those doctrines here. The findings of a referee decision become final for purposes of appeal under the statute within 20 days after issuance. All right. One of the key things, I think one of the key disputes we have in the case, Your Honor, goes to 443.151B6, which talks about the referee's decision is final unless further review is initiated under paragraph C within 20 days. The appellant's contention, I believe, is that final there means administrative finality. We think it simply means final order, the way an order of a court is final if not appealed with. It becomes final and therefore has to be appealed within a period of time. The cases that have cited always address the issue of a final order, not administrative finality. Under our rule, ironically, which we probably are going to take a look at, the substantive paragraph, the decisional paragraph, under our rule, as interpreted, can never be changed. And that's a long-standing rule that I inherited that will not be standing a lot longer, but that's the key of our three prior decisions that were cited in this case. The appellant contends that all those cases lead to the Sherman and the others lead to the same result here. But all three of those cases involved a substantive change to the decisional paragraph. Now, as the court has pointed out, those three cases, Ms. Rolini is correct, those three cases, there are different circumstances, and some of them it was more equivocal as to whether the employer should have been charged. But all of them resulted in the employer, quote, getting to get out of jail free card. They did not get charged in cases that they normally would have because of errors that were made that were placed in the decisional paragraph and had become under our rules final, because under our rule you can't make a substantive change at any time. We did not consider in deciding those cases the issue of Taylor and other cases which give agencies inherent authority.
So your argument basically is this is not a substantive change because there was no change to the decisional paragraph.
That's correct, and it's an absolutist position. I understand it. In the context of a DOA proceeding, you might not buy that, and I probably wouldn't be arguing it. But in the context of an agency that rolls out 134,000 orders a day, this referee decided 40 cases.
134,000 orders a day.
I mean, sorry, in a year. This referee decided 40 cases in the week that this case was decided. 134,000 cases in a year from the Office of Appeals. They write them while they're trying the cases, they hang up, they go to the next one.
I think you do a great job, too.
Well, it's a lot of work to cover, and I would point out that in terms of fly-specking the Commission's work, we write a lot of orders too. 2,400 orders with last year with substantive language in them.
Now, what was the procedure here? There was a proposed, it was like an order to show cause.
That's the effect.
And they took the appeal from that. What was exactly the sequence here?
There was some confusion there, but our take on this, Your Honor, and this is following the federal mandates. You don't hard time people on procedure when there's a clear interest in challenging something. The proposed corrected decision was issued as a due process procedure, like an order to show cause. The appellant had the opportunity to request a hearing as to whether that should be entered. They filed with the department, but directed to the Commission an objection to it, which, because it was filed with the department, was in transit and had not gone through our jurisdictional section. So they clearly wanted to contest it, but by the time anybody looked at it, it was the corrected decision had been filed. So effectively, it became a premature appeal, and then once the corrected decision had been entered, jurisdiction did vest. And they filed an additional brief, but we take a similar approach to the appellate rules in that there is if a premature appeal is filed, you can toll or stay it until the appeal is timely, and that's the simplest approach for us to take. So they never appeared before the referee on the corrected decision, but they did timely preserve their rights to challenge it to the Commission, and hence the Commission order addressing it.
Do you understand them to be arguing that the appeal you are describing as premature was perfected and deprived the referee of jurisdiction to enter the corrected order?
We would not. Our rules do not actually permit a premature appeal. That was simply an action on our part. But I will tell you that since it is a common law ruling, we would never allow a party to circumvent the referee's action in the case. The purpose of a proposed corrected decision is to give notice, not to allow a party to do an end run. I understand that argument was made, but the Commission would not. We have no rule that would permit that interpretation, nor would we accept that as interpretation. The goal here is not to allow a party to game the system, allow a party to have a fair hearing on the system, which they got with the Commission. And they could have had with the referee as well if they wanted to address it with the referee and then appeal it to the Commission and get another bite at the apple.
Well, again, what is your answer to the question about finality? I mean, do these things ever become final?
They do. The issue is it a substantive change or not? If it's a substantive change, under our interpretation of our rule, it becomes final upon written. And there is no basis for amending. Again, that's something that we will probably take a look at. But if there is not a change, a substantive change to the decisional paragraph, then it becomes an issue of, our rule is essentially like 1540A. That is, it can be done at any time before an appeal is filed, as long as it's a purely clerical error. We view, even though the language will not be charged, would be deemed substantive, in our interpretation it's simply clerical because it's not in the decisional paragraph.
And the rule that describes the different parts of an order doesn't really say that, does it? It doesn't give trumping rights to the...
It is not, Your Honor, you're correct, it is not absolutely explicit that this is the final statement, conclusive over all other statements. That's always simply been the interpretation. It's been based on years of practice at nationwide and in terms of the way the federal government views decisions as well. Unless there's any other questions, I'll waive the remaining minute or so of my time.
Well, it does say affirmed.
It does. And I want to make clear that our argument is that no correction could be issued after the decision was final, and anything entered after that is a nullity. And this court said that as long ago as 1979 in the Revel case. I just want to read this to you because it's strikingly similar to what we've got here. This court said the June 21st decision of the appeals referee here became final within 10 days after the day of mailing, unless within 10 days after mailing further review was initiated in accordance with the statute. There's no specific provision for rescission or recalling of a final decision by the referee upon his own initiative. The statute provides that his decisions, quote, shall be final unless properly appealed to the board and unless the board, on its own motion, initiates a review of the decision. And in that case, too, this court said, it indeed appeared the rights of the appellant did suffer by reason of the cancellation of the prior decision in his favor. Now, I know that the commission wants to spend quite a bit of time talking about all of the justifications for changing the decision, had there been authority to change the decision. By making the due process arguments that the agency makes, it essentially concedes that this is a substantive change. Otherwise, there wouldn't be any due process rights implicated by the first initial decision. But in the end of the day, regardless of whether this order should have said something else initially, once it became final, it became final. And final is final. And it doesn't mean that there can be a never-ending series of clerical corrections to referee orders for years in the making. That does interfere with the notions of administrative finality. And that is the threshold that the Florida Supreme Court and Taylor put on it, that where there is some sort of inherent authority to make corrective decisions, it is only in the circumstance where it doesn't interfere with administrative finality. And the department doesn't have a good answer for when that really becomes final.
I don't see why you say the due process argue concedes that it's a material change. In other words, they're saying that you might have been lulled because of uncraftsman-like order. And their position is that they are not making a material change.
Well, and of course, what they would have been lulled by is a sentence that says WHS Trucking will not be charged. And what they want to change in the corrective decision is that WHS Trucking will be charged. That is the entire outcome for WHS Trucking. It's the very reason that an employer participates in these proceedings, is to ensure that it's not charged. And once WHS Trucking had a decision that said it will not be charged, then if...
But the reason WHS went to the appeals referee was because they had been charged, and then they ended up with a decision that said affirmed.
Well, there was an agency determination that the employee would get benefits and that WHS Trucking would be charged. Then WHS Trucking got an order that said, Mr. Henry will be able to receive benefits, but WHS Trucking will not be charged for those benefits. And at that point, the employer was satisfied with the order that it received. It was after that that the notice of charge was issued. So while there is this argument about the decisional paragraph and whether or not this is clerical, at the end of the day, it doesn't matter, because clerical revisions can't be made after the order is final either. And otherwise, what we would have is a never-ending string of revived referee cases and new appeals to the commission and new appeals to this court off of corrective decisions that could happen months and years down the road. And it could happen if a new administration comes in and decides that they don't like the way that cases that preceded it were handled. They could come in and make corrective decisions. It's very disturbing, and it's the reason why we wound up taking this appeal, because at some point these orders have to be final, especially in a process that's geared towards making sure there are efficient determinations that don't wind up breaking the backs of small businesses that have to participate in them. Unless there are any further questions? Thank you very much for your time and consideration.